Insights brought to you by the National Referral Network. This is where we share professional wisdom and, yes, insights with all of you for the edification of professionals and regular people. And today we're joined by Maurice Fitzgerald. He's talking to us from San Francisco. I think you're overlooking the Bay, so I am not. I don't know what's in my background, but it doesn't matter. Maurice is here. Maurice is he's an employment attorney, and we're going to talk a little bit today about some of the changes in employment law, some of the things that employers should know, especially as it relates to remote work and all the changes that have happened in the workplace. So, Maurice, thanks for giving us a few moments. I want to launch into my first question, which is, what makes you and your firm unique? What's your superpower?
Hello, Mike. Good morning, and thanks for having us on board. My firm is O'Hagan Meyer, and we are a national firm. We are somewhat of a growing firm. Started out in Chicago and now have offices all over the United States. Attorneys who could basically practice law in most jurisdictions in America and most of the states. So our firm is growing relatively quickly. Started our reputation in litigation, meaning lawsuits, and primarily employment. It has grown from there. So what we have is lawyers who can handle everything from employment to real estate, corporate law, contracts, entertainment. We also do sports and sports law and all types of litigation. So that's where we built our practice. And as you said, I'm in our Northern California office in San Francisco, and I am, as we speak, looking out over the San Francisco Bay, looking at Alcatraz Island here. So gorgeous place to practice law, and California obviously is an ever-changing and growing area of law, particularly with employment law.
Well, go Giants! You know,
go Giants.
I'm a Bay Area kid myself. So you specialize in employment law, and we were sort of talking before we got on here about the space of employment law and how much it's been changing, especially because of what happened during the pandemic and how people transition from going into an office and now doing remote work. How has that changed the field of employment law, and what should employers be paying attention to?
Well, you're absolutely correct. You know, I read a recent study that from the Pew Institute that said that 57% of remote workers today had never worked remotely before. And so for those employees and for their employers, it has been a challenge to try to figure out, well, what do I have to do to make sure I am in compliance with the law? It's been obviously it's a great advantage for employees and employers too to have that type of flexibility. But the main considerations that have come up as far as my practice goes are clients who want to know, what do they have to do to be in compliance with the law if they are going to have their employees working remotely? Remember, we did this on a very quick basis. When we shut down San Francisco and other cities and sent everybody home, we didn't have anything in place to make sure that we were compliant with the laws. This was done very quickly, loosey-goosey. Most employers just were flying by the seat of their pants. They called us. We didn't know what to advise them in some instances because it was also so very new. But there are consistent things that employers should know if they're going to have a business that has the majority of its employees working remotely.
Okay, so let me give you a scenario. Suppose an employer that's renting a whole bunch of office space says, you know what, my workforce is okay with working remotely. They want to work from home or they want greater flexibility. Our lease is up for renewal. We're not going to renew it. I'm going to have everybody work remote. We get just as much work done. If they talk to you, what are you going to tell them about how to stay in compliance given that scenario?
Well, that's a very, very common scenario. In fact, as I look out over the buildings in San Francisco, it is stunning to me just how many of them are dark. In other words, in the evenings, you'll look and you see the windows. Some you can see that there's floors that are being utilized, and San Francisco has been the slowest in returning back to full occupancy, and that's because of what you suggested. Many of these offices the leases are coming up, and the employers are doing just what you suggest. They call me, and the first question I guess I would have is for them is, they're working remotely from where? Where are they working remotely? Are they staying in the local city? Are they working nearby? Because one issue that comes up are the various state and local requirements with respect to pay, tax consequences, and so on and so forth. They have different states have different tax obligations. If you are, for example, if you are working remotely and you're working in a different jurisdiction or state, the law states that gives what's called the physical presence rule. So, in other words, it is where you are doing the work that you are taxed. That could be, in some instances, a different state, right? In San Francisco, it's not as big a problem. But what if you're in New Jersey and you're used to commute to New York? Now you're working primarily in New Jersey. There are considerations you have to have for that particular.
So in other words, if your workforce all of a sudden splinters and says, "Oh, great, we can work remote," so I'm moving to Utah, okay, or I'm moving to a state with no state taxes. Does that mean, the payroll department has to adjust all the withholdings and all and adhere to all the laws of those states? And does that open up a brand new can of worms?
It opens up a can of worms. Big companies hire lawyers like us to help them with the compliance of that, to draft handbooks. And you'll see for companies that have remote workers throughout the United States, it'll spell out various jurisdictions. If you're in California, this is what you'll be required to do. If you're in Hawaii, if you're in Utah, and so on and so forth. But you're right. The payroll company has to be sophisticated enough to understand that there could be withholdings in one jurisdiction and not another. And sometimes withholdings in California and Utah, and perhaps even a third location, local taxes.
Okay, so if you're an employer and you're going through this transition at any level, I got two questions. What questions should they be asking of people like you, and where do they go to get the best information possible so that they don't step on a landmine?
Well, that's just it. The first questions they have to, first thing they should do is consult an employment lawyer if they have any concerns whatsoever. And the questions the employment lawyer is going to ask them are those same questions I was suggesting there. Where are your employees going to be located? And how do you intend to account for their time? How do you intend to account for the requirements of the various jurisdictions? For example, California has different laws with respect to medical leave. California has different laws than Utah or almost any other state with respect to overtime and payment and pay requirements, including classification and so on and so forth. You'll want to make sure that your handbook spells that out. And the pitfalls is ignoring it, frankly.
Right.
So many of my clients have come to me and said, well, it's been 2 years now. My employees are working remotely. One moved down south to the desert. Another has moved out of state. I haven't really done anything to address this. Do I have a problem? And the answer is not yet. But it's very easy for an employee to claim that you were out of compliance, and that could bring all kinds of legal headaches.
And let's segue to compliance for a minute, because first of all, how important is it for employers to actually have a handbook? Because my understanding is most small businesses don't have one. Mm-hmm. And how important is it for employers to enforce the policies that are in that handbook so they protect themselves from legal exposure? I think you know which road I'm going down here. Okay. How important is it for all of that stuff to happen? And should employers have a dedicated person in-house that's doing that?
I don't see a reason that any employer should not have some kind of employment handbook. The employment handbook will spell out the rights of the employee and the obligations of the employer and the rights and obligations that the employee has to the employer. So, in other words, the employee can't claim they were unaware of this obligation they had. For example, the obligation to report all your time. One of the biggest pitfalls that an employer runs into when working remotely is the possibility that some employee could claim they were working off the clock. They were working throughout their lunches. They didn't take any breaks that day. And as an employer, the reason you have a handbook that spells out your requirements that you are allowed to take an uninterrupted meal break, rest breaks, and so on. is not so much to inform the employee, although that's important, but it's to ensure that they can then demonstrate to a court or any sort of administrative body that they do allow for meal breaks and rest breaks.
Mhm.
And absent that particular provision in a handbook, it's easy enough for an employee to claim that they were unaware that they even had the opportunity to take a meal break. It's very important, particularly in California. The law has recently come down, not too recently, but in the past several years, that said as long as the employee is made aware that they have a right to this meal break, then you as an employer are okay.
Got
And
it.
so, go ahead.
And oh, I'm sorry to interrupt. Go ahead.
No, and similarly, I mean, a question has arisen recently for me that the postings that are mandated, right? If you go into any office and you go into their break room or a conspicuous place, the copy room, there are postings that set forth the rights you have for medical leave, non-discriminatory postings, postings with respect to minimum wage. How do you do that if you are remote? And there are mechanisms to do so. It has to be something that an employee is aware of, can access easily, and that there are routine communications back and forth between the employee and the employer with respect to their rights under to be
Right.
aware of such postings.
And I'm curious because we all from time to time hear about the more extreme cases, somebody claiming, I don't know, hostile workplace or hostile work environment, for example. I don't like the way my boss said good morning to me, and so I'm going to claim hostile workplace. Some of those more beyond the pale extreme cases that nonetheless do come up, do trouble employers because they at the very least create an unnecessary inconvenience if the cases are without merit. And then, of course, there are those cases that do have merit. Okay.
Right.
First of all, how do you separate all those out? And what should employers be thinking about? How do they protect themselves the best they can from this kind of thing? And what should they do if, for whatever reason, erroneously or not, somebody claims something like that?
Well, that is actually, you've touched upon precisely the type of work I do and that O'Hagan Meyer specializes in. And that is the claims that come forward. Are they legitimate? Are they not with respect to an employment claim? As you suggest, sometimes they are and sometimes they are not. For the claims that are not, well, let's start with the employee handbook. Again, the employee handbook should spell out what to do if you feel you are a subject of some type of discriminatory action or harassment or sexual harassment, things of that nature. And that employee handbook will spell out who you must contact. And if it is a supervisor of yours, in other words, you can't report it to your supervisor, that is the person who's engaged in this conduct, to have a hotline or some other manner in which you can report it, go around your supervisor. And then when they make the claim that I was harassed, the question then can be brought forward. Why did you not avail yourself to the policies and procedures of the company to prevent it or to stop it? Harassment, I get calls all the time about we have a hostile work environment. That is a term of art. So it's very specific. It doesn't mean your boss comes and yells at you every day. It could be a very kind and sweet comment that they make to you that's completely inappropriate. But sorting those types of things out, the best thing to do if you hear even a whisper of it is to reach out to an employment lawyer and let them know so you can immediately take action to either stop that or to and one of the claims is you have an obligation to do a quick investigation and to take steps to immediately prevent that from happening further.
So as we wrap up here, I have one last question. This is obviously brought to everyone by the put on by the National Referral Network. A little tongue-tied here. How has your membership in NRN helped you become a better professional?
Well, having the opportunity to just see the breadth of individuals who are associated with the NRN gives us resources, I think, to expand our practice. It gives us access to other professionals who have similar interests and similar needs. We as lawyers require the same types of services that other businesses require: financial services, advising clients on what to do with their finances at times, seeking out expert advice. Lawyers, litigators often require expertise, and to have a resource to actually seek out and see what professionals out there can possibly provide us with a testimony to support our position, that's crucial to us.
Yeah. Well, I appreciate that. And if you're a professional and you're watching this, check us out at www.nrnamerica.com. There's your contact information that's scrolling at the bottom of the screen here. We believe very strongly that no professionals are islands unto themselves, and yet we live in a world where we want to provide as many solutions as possible to the people we work with. So we have to be linking arms these days with other professionals that do things beyond what we do for the sake of that, and that's what NRN is all about. So check it out. You won't be sorry you did. Maurice, really appreciate you giving us a few minutes here today. That was really interesting stuff. Employers, if you have any questions, need to avail yourself of somebody with Maurice's expertise. There's his contact information at the bottom of the screen. And as always, we will be back next week, same time, same station, with more conversations with more professionals. So stay tuned. There's more to follow. Thanks, everyone.
Thanks, Mike.